Broadcast is now starting. All attendees are in listen-only mode.
Good morning, and thank you for joining us for today's webinar, COVID-19, the FFCRA CARES Act in your workforce. We'll be getting started in just a minute, but before we get started, I just wanted to go over a couple ground rules for today's webinar. Everyone will be placed on mute throughout the webinar. If you do have questions, please submit them through the questions tab, and we'll do our best to get back to you with an answer. At this point, I would like to introduce today's presenters. As a partner in our tax department, Joe Fian has almost 20 years of experience providing a wide scope of tax services for a diverse group of clients, ranging from small, privately held businesses to Fortune 100 companies. He has extensive knowledge of state and local tax planning, as well as a keen understanding of the impact of federal tax reform on multi-state filings. Frank Levesque is a director with Balloon's Human Resources Advisory Practice, providing HR and people strategies and solutions for clients throughout New England. Frank brings expertise and best practices from 25 plus years of HR business partner leadership and consulting experience across a wide variety of industries and organizations, from small family-owned businesses to large global corporations. At this point, I'd like to hand it over to Frank Levesque to begin today's presentation.
Great, thanks, Jared, and good morning, everybody. Our objective today is really to not spend too much time on what I would call sort of the higher level aspects of the FFCRA, specifically as they relate to the sick and the family leave and the associated payroll tax credits, only because I know that we've all been inundated, I'm sure, with tons of information over the past few weeks. And so what we're really going to try and do today in the time that we have is to look at some of the more common themes and questions that are coming up in our firm with our clients, and also maybe some of the more nuanced questions and scenarios that may catch employers off guard relative to administering this new legislation. Understand too that as much as this is about legislation, the spirit of this law is really about trying to ensure that employees aren't having to choose between paying their bills and their own health or the health of others, but at the same time trying to ensure that businesses are operating at a capacity that allows them to weather the storm and to come out and emerge from this crisis perhaps in an even stronger position. So at the end of the day, as much as we have to follow the rules around this, and you'll hear me mention this a few times, common sense and flexibility and collaboration, and of course consistency really should rule the day. So if we look at our agenda, we're going to take, if you just go back one, there we go. If we just take a look at the agenda, we're going to cover the emergency sick and family and medical leave and answer some or address some common questions, and then I'll turn it over to my colleague Joe for the payroll tax credits overview. And then we'll offer some insights to finish up that will speak to kind of where we're at today and where we see things going from here. Thanks. Common to both the sick and family medical leave, and again, there are two components here, but is the effective date of April 1st. So this is already in effect and will be until December 31st of 2020. Notice must be provided to all employees, should have at this point, and that can be done in the way of certainly the physical poster that must be posted in conspicuous places within your offices, but also in light of how many folks are working from home these days, ensuring that they are provided this notice electronically, which can be done very easily. It applies to all employers that have under 500 employees. That would include full-time and part-time and temporary employees, as well as any employees on leave. However, it would not include employees that are on furlough or on layoff. And it includes nonprofits and certain public agencies. There are some exemptions for employers that have less than 50 and less than 25 employees, which we'll be speaking to in just a minute. And really, these two components are designed to work in tandem with each other, and we'll talk about that as well. And then I will, of course, turn it over to my colleague Joe to talk about the payroll tax credits that are associated with this, and understanding too that the regs and the sort of the interpretation and the clarity around this through the Department of Labor and the IRS seems to be changing quite often. So this is as we understand it today. So if we look at the paid sick leave component, there are a couple, as much as there are commonalities among the two, there are differences. And so with the paid sick leave, there is no employee service requirement. So day one, employees are eligible through December 31st for this leave. There are 6 qualifying reasons, and most of those reasons under the paid sick leave are at 100% of pay, up to 80 hours or 2 weeks. And that is essentially if an employee is unable to work because they've been ordered to quarantine or isolate by the government, state, local, or federal government, or a healthcare provider, or if they're exhibiting symptoms and they're in the process of trying to get tested. During that time, they are eligible for 100% of pay up to a cap of $511 per day for both the pay and for the eligible pay and for the tax credit. If they are out on sick leave to care for a son or a daughter whose school or daycare has closed because of the COVID-19 pandemic, or as yet undefined, any other substantially similar condition, they would be eligible for 2/3 pay at $200 per day, and that is also for the pay and the tax credit cap. On the actual family and medical leave, now this is an amendment to the existing Family and Medical Leave Act, which typically doesn't apply. Well, the regular Family and Medical Leave Act only applies to employers with 50 or more employees, and does have other service requirement criteria. In the case of the emergency family and medical leave, it's a 30-day service requirement, and basically for one qualifying reason, and that is to care for a son or a daughter with school or daycare closure issues relative to the COVID-19 pandemic. I will add that if there is an adult son or a daughter who's typically in an adult school or daycare and they're unable to care for themselves because of a mental or physical disability, they would also qualify. Now, the first 2 weeks of the family medical leave are unpaid. However, as I mentioned earlier, the family medical leave and the sick leave are meant to work in tandem with each other. So the employee can use employee sick leave at 2/3 pay for this reason for the first 2 weeks, which would then be followed by 2/3 pay to a total of 12 weeks. Now, if they've used existing FMLA leave in the past year, depending on whether you're using a rolling calculation or a calendar year, that would apply to their eligibility for this leave as well. You can't have 12 weeks of emergency family and medical leave and then 12 weeks of standard family and medical leave, all within the same 12-month time period. There's, as I mentioned, a $200 per day pay and tax credit cap on this benefit. So as we look at some of the common questions, I think that the first one should be, well, what should I be doing right now? Well, determine if your company meets the 500 employee threshold. We'll talk a little bit about how to do that. At the same time, you should be notifying all of your employees of their rights. And this is a link to the poster. Very simply, if you go to the Department of Labor's website and search for poster, FFCRA poster, you will come up with this poster. And at the same time, ensure that your payroll and accounting systems and processes, the way that you're going to track this is updated, whether you're doing your own payroll or you're having a payroll provider do your payroll for you. You want to make sure that you're capturing this accurately, certainly calculating it accurately, but capturing it accurately because ultimately you're going to be looking for tax credits, and you're going to need to make sure that you're tracking and documenting this properly in order to support those tax credits. So how do I determine if I meet the 500 employee threshold? Again, you're going to include all full-time and part-time and temporary employees. This would also include any day labor or temporary agency employees that you might have that are working for your company. Independent contractors are not included. I should mention anybody on leave as well would be included. Independent contractors are not included. This applies only to employees in the United States. So if you're part of a larger entity that is headquartered outside of or has a location outside of the United States, only those employees in the United States would be counted. Now, the determining factor as it pertains to EPSL and EFML, it's what's called the Joint Employer and Integrated Employer tests. Both of these tests are used for generally different reasons. The Joint Employer test falls under the Fair Labor Standards Act, which has to do with wages. The Integrated Employer test under FMLA. There are commonalities between the two, and essentially, and there's really nothing quantitative about it, it's more qualitative, and by that I mean it's simply asking certain questions around commonality. Are you hiring, do you have hiring and firing decision commonality between two entities? Scheduling, wage determination, are the personnel records stored in a centralized place? Do you have common management, operations and ownership? And certainly I'm paraphrasing here, but that's really what the determining factors are going to be. There is no one determinant. And a good place to start is the IRS does have an FAQ, which we have a link to here, that also links to the Department of Labor's website, which further explains in more detail how to go through these questions. So, you know, a good example might be if, as I mentioned, if you're employing temp agency employees, that would probably be a joint employer relationship. Or if, for example, you had three restaurants, and the same ownership team managed and owned those restaurants and shared employees, that would also fall under that. Another question that's come up a lot is around employees being eligible for leave if their company has been shut down due to the COVID-19 or due to COVID-19 related government orders or drops in business. And a good example of this is in the Boston area. The construction in Boston was essentially shut down by the mayor. And so that, not surprisingly, put a lot of people out of work. And the fact is that they would not be eligible for EPSL leave or EFML leave simply because they are at work, they are at home because of the drop in business, not because they've individually been ordered to quarantine or self-isolate or be home with a child. So employees who are unable to work because of a shutdown, however, are eligible, may be eligible for unemployment insurance benefits. Another question that comes up quite a bit is around the exemptions for small employers. This one has to do with less than 50 employees, and it can really only apply to the child care related sick and family leave. And so an employer with less than 50 employees, if they meet any of these criteria, they would then potentially be able to demonstrate exemption from allowing someone, an individual, to go on child care related sick and family leave. And so the questions you need to ask are, is the cost of allowing this person to go on leave more than I'm actually able to afford? And is it someone who is, or is it someone whose specialized skills and knowledge and not having that on my payroll, is that going to present a substantial risk to my business? Or can I just not find adequate replacement labor to operate at a minimal capacity? In other words, it has to be a significant impact on the business. And if any of these are demonstrated, you must, or an officer of the corporation must document that in writing. You don't need to send it to the Department of Labor or any other entity. You just need to make sure that you have that documentation to support that decision. Now, there is another exemption that exists for employers with under 25 employees, and that is relative to job restoration, also for the child care family leave. And so in that case, you would have to demonstrate all four of the following: basically that the position no longer exists, and that you've made reasonable efforts to restore that employee to the same or an equivalent position, and that you are making good faith efforts to keep in contact with that person both during that time and for the year following that. Now, you would hope that these are the exception and not the norm, and I would expect that that would be the case, but it's important to know that these exemptions do exist, but at the same time, being very careful about these decisions and making sure that you have adequate documentation to support it. And speaking of documentation, what notice and/or documentation can I ask for? And so again, flexibility and collaboration and understanding and support are really should rule the day. However, you want to make sure that employees that are asking for leave are legitimately eligible for that leave. So it's striking a balance really between the two. You should ask for notice as soon as practicable, which should be in accordance with how you would ordinarily ask someone to provide notice for leave. And as far as the information that you can require, we're actually in the process of developing a form to make this easier for clients, but it's basically a request form, and this is kind of a combination of the sick and the family leave information that you'd be looking for. But essentially, an employee would provide you with a statement in writing that just indicates the dates for the leave, the qualifying reason for the leave, which must fall under one of the 6 qualifying reasons, and that they're unable to work because of that reason. If there is a government entity or healthcare provider issuing that order, who that is, or the name of the school, if that's the reason. And then if they are home caring for a child, that there is no one else able to care for that child during that time. You can also, for the first 3 reasons, ask for a doctor's note. You certainly want to ask for doctor's notes when it comes to an employee being able to return to work. But again, we want to use common sense and understanding in these situations. And if someone is legitimately sick, try not to be draconian about it, but get enough information that we can at least support the eligibility for this leave, and ultimately also be able to support the tax credit that would go along with it. Another area that has come up that is perhaps unclear to some, and we're still looking at pieces of, is the regular rate of pay. And so the law basically says that employees that are eligible for leave should be paid their regular rate of pay at either 100% or 2/3. Now, that's very easy to do when you have someone who basically makes a straightforward salary and has very little variable or additional compensation on top of that. So in the case of someone who makes $100,000, and the guidance is to look at the last 6 months to average out their regular rate of pay. But in this example, which is very simple, we've got a $100,000 a year employee who basically, if you drill down, is at $1923.08 a week or $384.62 a day. That would fall under the $511 cap of 100% paid sick leave. However, it does exceed the $200 cap of the 2/3 paid leave by $56.41. So whether it's the paid sick leave or it's the family leave, there are opportunities to supplement those caps with any other available accrued time that the employee might be able to avail themselves of. Now, it gets a little bit more complicated when we're talking about regular rate of pay that includes other compensation, for example, non-discretionary bonuses based on performance or output or tips. Ultimately, employees need to be at or above the state or federal minimum wage, whichever is higher. But in this case, we have an employee, same annual salary, but also gets a quarterly bonus of $10,000. In that case, over the past 6 months, the average daily rate, hourly rate, which translates to a daily rate, is actually more, and it would exceed both the $511 and $200 per day caps. Again, those are caps for the leave itself and also for the associated tax credits. It does not mean that the employee cannot then use other paid time off to try and supplement that. Another question is around part-time employees, and in the regs, they list a number of different ways to calculate part-time employee hours and pay, and it gets a little tricky when the part-time hours vary, but by and large, if the employee is scheduled to work 20 hours a week on a pretty regular basis, you do want to look at the past 6 months, but at the same time, be mindful of any variability that might happen with their schedule. But it's pretty straightforward. If they're scheduled to work 20 hours a week, that's generally what they're working, then that's what they would be eligible for over a 2-week period. Now, if the paid time, the part-time schedule varies quite a bit, the easiest thing to do really is to just average what they've been working over the past 6 months on average. And if they've been there less than 6 months, what did you agree to when they were hired? And or at the end of the day, if you have to average out only 3 months of hours, then that's fine too. Ultimately, it's really about making sort of a good faith effort about what is understood to be their average ordinary schedule. Healthcare workers and emergency responders, are they really exempt? Well, they may be. And the reason why employers may be able to exclude them is because of their essential nature. However, the Department of Labor has recommended that employers be judicious around this. Certainly, they don't want sick people out in the field, and they want to minimize that as much as possible, so that as essential as they are, employers really need to be, as the DOL says, judicious around excluding or exempting healthcare workers and first responders. And then some additional questions that came up recently around include, for example, what should we do with employees who choose not to come to work out of fear? The protections that exist for employees relative to this really primarily involve situations where they feel like they are going to be entering a imminent danger zone, one where a serious or immediate threat or harm will come to them, and that falls under OSHA. And so really, again, what the suggestion is here is that you work with the employee individually. Hopefully this is more the exception and not the norm. And while you may not be obligated to pay them, you want to try and be flexible and supportive. So can they can they work from home at all? Is there any paid time off available that they can use? Ultimately, if you can't figure something out, then that employee can then try and maybe be eligible for applying for unemployment. What considerations should there be in deciding whether to implement pay cuts or furloughs? And we would say that you always want to start with the business needs. What is it that needs to continue happening? What work is there still that is ongoing? What's the anticipated workload? And at the same time, what are the financial reserves and resources that you've got to continue? And marrying the two, what are the skill sets and the specific key people that you need to get that work done? You want to make that decision, you want to walk through that decision process, obviously in a very non-discriminatory way, to make sure that you're not singling out any particular groups that are otherwise protected classes by law, but they're really decisions that are rooted in business knowledge and common sense. So ultimately, it could be a combination of salary reductions, furloughs, and keeping people working. I've had clients that have implemented one of them. I've had clients that have implemented several of them. I would also recommend that you not do that without the advice of counsel. And also, if you're looking to continue health insurance for your employees, which many of our clients have tried to do, make sure that your plan documents, as they relate to what you can and can't do with employees who aren't actively working, reflect that you're able to do that. And then just to finish up, intermittent leave, is that okay? Or it's okay with us? How does that work? It's an agreement between you and the employee. Again, it's about flexibility. So if the employee is able to continue working in some capacity and also avail themselves of the leave, that's certainly what you want to try and do when you can, especially if you're looking to retain employees and keep people working. The only caveat to that is you don't want folks working intermittently at the office or on the job site if they're sick. So really, if you're going to have them come to the office and work or come to a work location and work, it really can only be for that child care or that school closure reason. And then lastly, do we pay FMLA 2 weeks before we pay any sick and vacation time? Example, I have an employee out for being quarantined for 2 weeks. Do I use his existing time off to pay him, or does he go straight to FMLA, or do we get reimbursed? If so, how do we get reimbursed? I'll let my colleague Joe speak to the reimbursement piece, but this is pretty straightforward. The employee would go straight to EPSL, the sick leave, for 2 weeks, and then once that's exhausted, that employee would then be eligible for any other paid time off that the employer might have available to that employee.
Great, and I think if we can just go back to that slide for 1 second before we start the payroll tax credits, we'll get into the reimbursement in subsequent slides. But essentially, the mechanism is it's intended to be dollar for dollar, and you will use the money you'd otherwise deposit for payroll tax to pay the employees. So we'll get into that. I just had a couple other thoughts on some of these questions before we get into the tax section and how the credits work. If you're deciding to do pay cuts or furloughs, I'm sure a number of you, or maybe all of you, are signed up for our webinar tomorrow morning on the tax aspects of the CARES Act. There are payroll credits in there that you may want to consider when doing pay cuts. Also, if you're applying for a paycheck protection loan, there's a head count that they want to see you keeping the jobs. They'll compare you over the prior year. Doing layoffs or furloughs, it may impact the amount of money you can have forgiven on one of those loans. And again, that's more of tomorrow's webcast. Also on intermittent leave, we'll talk on that a little more in the next section of the presentation. Intermittent leave is something that the IRS FAQs are encouraging, and you'll see some situations that we'll talk about where you might have two parents and people are both eligible for leave, and you may want to work flexibly with both employers to ensure coverage, right? So really what the FAQ is coming down, and as Frank talked about, they're really encouraging flexibility, right? Let's make this work. So those are some additional comments I had on these questions. We can probably jump into the tax section now. So again, Frank, thank you for the first presentation. Great job. Thanks for setting me up to kind of, table set for how the tax credits will work. So really what we have here is, and again, this is Joe Fee, and I'm the tax partner kind of addressing all this. So again, we'd encourage you guys to reach out with questions. There's also really some great FAQs that the Department of Labor and the IRS have up on how this will work. So really the first thing to understand here is this is intended to be a fully refundable tax credit to cover the cost of leave paid for the time when employees are unable to work. And I think Frank kind of went through that. You have to be unable to work, so you actually have to be sick or caring for a child at home. And there are provisions in the guidance that would, when they say unable to work, the office is closed. Well, can you work from home? I'm providing care. Well, can you provide care and work from home? And we'll get into some guidance a couple slides later on how the IRS even looks at like the age of the child for care. So children will get to a certain age and they can say, well, you can be home working and the child can sort of take care of themselves. There are situations for certain self-employed persons in similar situations will get the credits, and we have a slide to walk through how that is intended to work. So if we can move on to the next slide. So the payroll taxes intended to be included would be the employer share of your Social Security and your Medicare taxes. Remember, Social Security is capped. There's a wage cap on that. Medicare is not. And then there is the employee share of Social Security and the employee share of Medicare, 6.2 and 1.45. When you determine the amount of tax, you're going to look at the above amounts for all employees, not just the employees claiming the sick or the family leave, right? So that's important because that's going to give you a bigger pool to kind of credit against. And you look at the entire amount. So for employees not taking sick leave or family leave, you'd make the regular deposits that you would, for your quarterly deposits for payroll taxes. For the employees taking the leave, you'll take the money and use that to pay out. So again, look to your total amount deposited, then reduce for the amounts paid for sick and family leave. And we have a couple examples that we'll discuss those. So again, as I mentioned, you're going to use the amounts otherwise required to be deposited. And there's two ways you can claim the credit. You can claim the credit on your Form 941. That's the quarterly form that you file to remit employment taxes. However, in order to get the benefit quicker, the IRS is permitting you to take the money that would have been deposited and use that to pay the employee. If the sick and family leaves exceed your required IRS deposits, there's a mechanism to request an accelerated payment, and there's a new form out, Form 7200, which you would submit to claim this. The IRS is telling us that they expect to be able to process these claims in 2 weeks. Now, this law became effective on 4/1, so I guess we'll see how, it might be a while before we see if that's actually going to be the case, because you would think, right, people are probably just putting in claims now, and in order to have a claim, it would have to exceed the amount of other deposits required. So, but the IRS has put out there in guidance that they think they can pay you in 2 weeks. What about self-employed people? Well, it works almost the same, but there's a little bit of a difference. The self-employed individual can claim the credit when they file their 1040, but that of course means waiting till next year. So how do they get cash immediately? They are also allowed to reduce their estimated tax payments that they would otherwise make if not entitled to the credit on the Form 1040. So again, like the employers, they will take the money that would otherwise be deposited and use it to pay themselves sick leave or family leave, again, with the caps that Frank went over. Unfortunately for the self-employed, a refund is taken on Form 1040, not the Form 7200. So again, that's a key difference. If you're due a refund, you have to wait. Now, a lot of people are asking about proper documentation of this, right? So again, how do we document this so if we're going to be audited, we can show that we did everything correct? So the IRS has given some guidance on this, and to summarize that, they're looking for the employee name, the date or dates requested, and we need a statement of reason that the leave is requested, including written support. So as Frank went over, there are 6 reasons that you can take sick leave or family leave, and you would need to kind of document one of those reasons, and they say including written support. So for example, if you are under quarantine by way of a health professional, you probably, a note from your doctor or something like that. Now, I think the nice thing about this is there's been, a 30-day kind of suspension of enforcement, and you can probably go back later and get this information to kind of paper the file, right? So this is looking down the road when things return to normal. We should be able to get some of this work. We also need a statement that the employee is unable to work. And again, this includes telework. So a lot of people who are home are going to be able to work. And this might be, you might be able to work even if you're caring for a child, or even if you are sick, you may be able to work. But again, I don't think they're going to enforce it that, well, hey, try to work through the illness. It's, again, people being home and being able to work. If the leave relates to a quarantine, the name of the government entity or the healthcare professional ordering the quarantine. For the government entity, that should be pretty straightforward, right? That is a matter of public record. And we'll talk on the next slide. There are additional rules for the care of children. This works a little bit differently. For child care leave, the IRS is recommending that we document the name and the age of the child. And we'll talk about the age of the child in a second. The name of the school, this would presumably allow them to cross-check that the school was in fact closed. And then a representation that no other person receiving leave is available to provide care. So in the case of two parents, what they're trying to prevent here is that we're not putting in for family leave to have both parents get paid for it, because one parent could work and one parent could be the care provider. This will be important when we get into the intermittent leave, because there will be situations where one parent can say, I'll take two days a week, and the other parent will take 3 days a week, and they'll be able to work it. And again, the guidance from the IRS is encouraging you to be as flexible as possible. Now, if the employee is, with respect to your inability to work or telework because of the need to provide care for a child over 14, and they say in the guidance during daylight hours, you would need to provide a statement that special circumstances exist requiring the employee to provide care. Right now, this obviously gets into real personal issues and things like that. But again, it's something that the people tracking these credits should be cognizant too. What the government is kind of saying is, hey, I guess if you have a kid in high school who's home, well, they should be okay, and you don't need, absent a special circumstance, you don't need to take leave to provide care. So what are the records to retain? So we want to retain documentation to show how you determined the amount of qualified sick leave and wages you were eligible to include. This could probably be things like memos to the file. And again, the first part of the webinar, when Frank went through how we calculate the wages, what wages are tips, what wages are bonuses, what wages are just straight gross wages, and then how we determined that you were eligible for the credit, right? And again, so people who are above the credit, what's not being included. If you're below the 511 a day, you only take up to what is actually paid out for 100% of the wages. And then we also want to include allocated the amount to wages. The Form 7200 should be included, and Forms 941, or if you use a third-party payroll provider, you should include the quarterly summary report or something to that effect. The retention period is 4 years. Now note, with payroll filings, these are quarterly filings. So again, they're going to be 4 years from the period the quarter was filed. I wanted to just touch base on a few things that are going to be discussed in tomorrow's webinar and how they interact with these amounts. So there is a paycheck protection loan. And part of the paycheck protection loan, they ask you to determine 2.5 months of payroll to determine the amount of your loan. You are not permitted to include in the cost of that payroll any of this sick or family leave. And the reasoning there is these amounts would be, you'd get a credit for these. So again, they don't want you including that in the payroll that's eligible for the loan. There's also a payroll retention credit, and you would use this credit if you retain employees, and you're only allowed to get this credit if you're not taking a payroll protection loan. So again, they're going to do a deep dive on the payroll retention credit on tomorrow's call, but essentially this is a credit that allows you to take the payroll taxes. You have qualified wages and you get to credit 50% of qualified wages, and it'll be a payroll tax credit for retaining that employee. And there's also deferral of employer Social Security payments through the end of this year, with 50% paid in 2021 and 50% paid in 2022. So these are all things that are other aspects of the law, but they do have some interaction with what we're talking about today, particularly the paycheck protection loans, and not including credits like this. The IRS provided guidance, IR 2020-57, and they provided 2 examples, which we can quickly go through now. And this really, I think these are great examples to just show really how straightforward the law is intended to operate. So if an eligible employer pays $5,000 in sick leave and they were otherwise required to deposit $8,000 in payroll taxes, they could use the $5,000 of the amount required to be deposited, the $8,000, to make qualified leave payments. So at the end of the day, you would only deposit $3,000, which would be due on your regular deposit day. So you see how the money is immediately made available and it gets to the employee. For an eligible employer who pays $10,000 in sick leave, and on this same amount, the required deposits were $8,000, they could use the entire $8,000 to make leave payments, and then they could file a request for an accelerated credit of the remaining $2,000. So again, I think at these numbers, if it's $2,000, that's not a lot of money, but maybe you'd wait till you file your 1040, or you could file the expedited request. So again, this is really the power of how we get the money into the hands of the people who need it as quickly as possible. So like Frank did, here we're going to address some questions that people submitted ahead of time. And these are questions from people who hopefully are on the call. Let's walk through what was asked. So the first question was, do you have to make FICA payments on the sick leave and family leave payments? And there was guidance provided that these are not wages for FICA purposes. However, special rules apply for government workers. So we're not going to go into a deep dive on those, but if anyone on the phone is in fact a government worker or curious about how this applies to municipal agencies, there's some additional guidance which gets into some of the nuance around how, these municipal agencies may make voluntary Social Security contributions and the like. It works quite differently. So if that applies to you, I would definitely encourage you to read the IRS FAQs and come back to us if you have any specific questions. We do have people who work with a lot of government agencies here at Bloom. So again, we're here to help you interpret these rules. Another question we got was how one would handle sick days when people are working from home. So really, I think the important thing here is if the employee is able to work from home, and again, we have requirements in the guidance that includes telework, they should not claim a sick day. So again, as discussed above, the IRS is requesting that the employers provide a statement that the employee is unable to work remotely. And again, as we talked about in the documentation requirements, this is something you would paper your file with and present to the IRS upon audit if you're asked to substantiate the credits. I think we've covered this question a lot in the earlier slides, but the question was, I know the credit is designed to be dollar for dollar, but how are wages reimbursed, right? So again, as we've walked through in the examples and we've walked through with the expedited refunds, the funds otherwise required to be deposited with the IRS are used to pay the employee. To the extent you exceed, as we went through on earlier slides, to the extent you exceed your required FICA deposits, you apply for the expedited credit using Form 7200. Unemployed individuals take the credit on their 1040 here, but in reality, they can, as I touched on earlier, they can take the money otherwise required to be deposited and pay themselves. What they can't do is take a refund. They have to wait for the refund until they file their 1040 next year. And I don't really know why that was done that way, but it is what it is. So again, you're limited to that amount if you're self-employed. The next question was, if an employee is offered the opportunity to work from home but chooses not to, are they entitled to paid leave? And this was a little more unclear, but my thought was it appears they would be. The IRS documentation for leave, if you look at the IRS documentation for leave that we went over earlier, the documentation does not require a statement of inability to work for family leave. Rather, it has requirements based on the age of the child and the availability of another caregiver for whom leave is available for. This is going to get into interesting situations too, right? Because we have situations where employers that have more than 500 employees, there were statistics I read that in that category of company, about 90% of those companies already offer sick leave. Now, they may not offer the 2 weeks required under this act. They may offer more. We may have a situation where an employer with over 500 people is already offering this, and care could be provided, right? So again, those employers wouldn't be reimbursed. So we may have situations where if you're in a department and somebody works for a bigger company where they're already getting leave, we have to work through that, right? So again, those are the requirements issued on leave. So I think if somebody said, well, you can work from home, and they said, no, I have to take care of the children, we would look to the availability of another caregiver or the age of the child. So I would interpret this that an employee with another caregiver who is getting leave and can provide care, or a child over 14 could not decline to work from home if given that opportunity. So again, Frank touched on this in his slides, but for paid family leave, it says the first 10 days are unpaid leave. So again, I think the idea here is you would, if it's for paid family leave, is you would work through the first 10 days as sick leave, but it would be capped at the $200 per day. And that's provided that the time has not been used for any other sick leave purposes. So for example, if you were subject to a quarantine and you used up those days, you wouldn't then get to also use those sick days at the lower rate. They're used up. And similarly, as Frank went over, an employee could also, to the extent those days are unavailable, they could draw down vacation time, or they could take the lower rate and use vacation time there to kind of make themselves whole. The another question we got were, how are employees from a temporary agency treated? And the Act uses the definition of an employee from the Fair Labor Standards Act. And there's also Department of Labor guidance that confirms all of an employer's U.S. employees who meet that definition are eligible for paid sick and family leave. This includes part-time employees, joint employees being people who work on multiple sites for maybe different divisions, and included in the definition are workers from a temp agency. So they would be counted. Frank also dealt with this question here, the intermittent sick leave, but I'll go into a little more detail on kind of the guidance that was offered. So again, the Department of Labor guidance left this decision to the employer. So I think if we stop right there, the employer could say no. But then they go on to encourage the employers to be flexible. So I think what the employer really should consider here is whether such a plan allows them to provide the statements regarding working remotely and the requirements for documenting family leave, right? Because again, you're going to have to kind of substantiate that for the file. So if you're looking at doing this intermittently, really look back to how we document the file for any credits we take. That I think would be the most important takeaway there. So I think here really to kind of begin to wrap up, and then Jared, I don't know if there are questions we've had submitted that maybe Frank and I could open it up to in the remaining 5 or 10 minutes we have. But again, I think really in interpreting these rules is make sure you're talking to your employees, collaboration and flexibility. That's what the guidance is looking for. Make sure you're doing this real time, right? If employees are requesting this leave, let them know of the documentation and substantiation we're going to need, right? Because it's easier to get that now than to go chase it down when you're audited, or even 6 months or a year from now. Again, as Frank pointed out, talk to legal counsel before making any of these big decisions. As I added, and for those people sitting in on the call tomorrow, those employment decisions around layoffs and furloughs and when you rehire people may impact the amount of loans that could be converted into grants. I'd also remind all of you that your employees are going to need a lot of help, and the state unemployment centers really, they're overworked, right? People are finding that they can't apply online. Obviously, there are people who are trying to apply online, apply by phone. Really leaving to go apply in person isn't an option. The Family First Act did include money to state governments to help with technology and other stuff like that. Really, the question is who best to, how quickly can we get it online? And Frank, I don't know if you have anything to you want to add here, but I think really those are maybe some best practices if there's anything you want to add.
Yeah, I would just say that I would echo those sentiments, Joe, and also, I mean, what I'm hearing from employees who are out on unemployment right now is that the unemployment centers continue to be overwhelmed, and that you know, whatever we can do as employers to help support them, we should. You know, the big one of the big issues right now is the self-employed 1099 worker claim. So there's only so much we can do relative to the unemployment support, but right now it's still a work in progress.
No, that's great insight. We have some additional resources here that I think we'd encourage you all to look at. The Department of Labor and the IRS both have really some great FAQs up that I find really will answer a lot of the questions that I'm getting from other partners internally or from clients. A lot of times the IRS will use a definition, and it'll be a Department of Labor kind of definition that they're looking to. I think that might be an appropriate question to kind of, for interpretation of the Department of Labor standards, that might be an appropriate question for an employment lawyer that you may use, or counsel. It's not necessarily a tax direct question if it's interpreting a Department of Labor rule. But these are really great FAQs. I'd encourage everybody to look at them, and again, you know, ask us questions if you have them. So, Jared, I don't know if there's well, a plug for our website here if you haven't seen it already. Bloom's COVID-19 Resource Center. This is where we're aggregating everything. So federal tax updates, state and local information on the loans, business tools and resources. I'd say this is your one-stop shop for everything. I'd encourage you to go and look there. We have toolkits you can download. Really, we're trying to be as responsive to you, our clients. We know how important you are. Jared, I don't know if we want to end a few minutes early, or if there are some questions that came in that maybe Frank and I could handle.
Yeah, I think a lot of the questions that came in were addressed or relate to some personal situations that we could take a look at getting back to them on. So, you know, I think at this point, thank you everyone who attended today. Hope you found the presentation informative. And again, we've got our COVID-19 Resource Center page that you can visit, see additional webinars coming up and additional resources to help. So I'd like to thank everyone for attending today.
Thank you.
Thank you.